Judge Ahlers, how are you today?
All right, how about you?
Okay, you can take your seat, and when you get comfortable, or when you get settled, we shouldn't say comfortable, you can,
You might be here a
begin
while.
your opening remarks.
Okay. Thank you. Good morning.
Morning.
My name is Paul Ahlers. I am a District Associate Judge in District 2B, presiding in Hamilton, Hardin, and Wright counties. I'd like to start my comments with a brief confession. Don't panic, it's nothing scandalous. When I made the decision to apply for this position, I was overwhelmed by the prospect of trying to find time to get around to meet with everybody around the state. Quite frankly, I was kind of dreading that prospect. It turns out my fears were unwarranted, because what I ended up being overwhelmed with was appreciation for the generosity and flexibility of all of you in making time out of your busy schedules to meet with me. So I actually ended up enjoying the process, so I wanted to thank all of you for that. Okay, confession aside, I want to begin by telling you why I want this position. Of course, all the applicants that you've seen yesterday and you'll see today want the job, and I am no exception. But at a deeper level, I believe that there is something more that drives me to apply for this position beyond a bare want. And that something is a belief that attorneys that have the aptitude and interest in becoming a judge, in my opinion, have the duty to their profession, to their communities, and to the people of the state to apply for open judge positions. And I feel the same way about sitting judges when there's openings for appellate positions. If you think about it, there are four types of people that could become judges. There are those that don't have the aptitude and don't have the interest. And of course, that would make a horrible judge. The second two categories would be kind of a hybrid, as people that either have the aptitude but not the interest, or the interest but not the aptitude. It's a little better, but still not an ideal situation. I think the fourth category of people are people that have the aptitude and the interest. And of course, that is the category we would all like to see our judges have. And I believe it is those people that have the obligation to apply for these open positions. Because if you think about it, if those people that have the aptitude and interest don't apply, then we're left with picking from the pool of candidates that fall into those other three categories, which is not an ideal situation. I believe I fall into that fourth category, and that is why I'm applying for this position. Now I want to tell you, or try to demonstrate for you, why I believe I have the aptitude and the interest such that it would make me the best candidate for this position. I like to look at this from the point of view of what characteristics do I look for in my appellate judges. And there are a number of characteristics, and due to time constraints, I can't list all of them, but I've come up with 7 that I think are very important. First would be strong academic background and intellectual capacity. I sometimes refer to that as candle power. I believe Mr. Berger referred to it as judicial horsepower, which I kind of liked. In an ideal world, I think we would all want our judges at the trial and appellate level to be the smartest people in the room. And while I don't claim to be the smartest person in the room, I do have a very strong academic background, finishing first in my high school class, finishing first in my curriculum and major at Iowa State, and finishing in the top 3.4% of my law school class at Iowa. The second characteristic that I think makes a good judge is relevant experience as a lawyer. I spent 14 years in private practice, during which the vast majority of my time was spent in family law and criminal law matters, which of course makes up a large portion of the workload of the Court of Appeals. I also have another layer of experience from my 3 years at Travelers Insurance Company, where I had experience dealing with class action suits, insurance coverage disputes, bank liability claims, securities litigation, and other complex matters. The third category or characteristic, I believe, is relevant experience as a judge. I think someone with trial judge experience is a very important factor. Quite frankly, after becoming a judge, I learned a lot of things that I didn't even know that I didn't know when I was a judge, and I don't think there's any way to simulate that experience. I have 8 years of experience as a trial court judge, and I estimate that 60% of my time was spent on criminal cases, or is spent on criminal cases, and about 30% is spent on juvenile cases, which again are very important cases in terms of the workload of the Court of Appeals. The fourth characteristic would be writing and research skills. Of course, one of the important jobs as a judge is to convey your thoughts and rulings in writing. I believe I have strong writing skills, as demonstrated by the fact that even though there's a very competitive process for getting law review articles published in law school, such that it's a big honor to get one article published, I was successful in having both my articles published when I was in law school, and I don't believe that writing talent has left me since leaving school. fifth characteristic would be work ethic. I understand that there's a tremendous volume of work at the Court of Appeals. I believe I'm prepared to carry that load, and I hope I know what I'm getting myself in for. Again, it might be that situation where I don't know until I get there what I didn't know, but I believe I'm prepared for that workload. I currently make a point of getting into the courthouse before it opens and frequently stay after it closes in order to get the work out. I'm very proud of the fact that in my 8 years as a trial judge, I've never had a case on the 2210 report, and I don't intend to ever have one. And I work nights and weekends to make sure that that doesn't happen. I have a belief that we have the obligation to issue timely rulings because frequently justice delayed is justice denied. And I will carry that belief with me to the Court of Appeals. The sixth category or characteristic, and I believe this is one that sets me apart from the other fine applicants that we have here today, is knowledge of the law. Perhaps the best way I can illustrate that I possess this characteristic is for the better part of the last 20 to 21 years. I have read, analyzed, summarized, and given presentations to lawyers and judges around the state on the published opinions of the Iowa Supreme Court and Court of Appeals doing the case law update. This has not only been a form of public service that I perform, but has resulted in me accumulating a wealth of knowledge that, again, I believe sets me apart from the other candidates. Seventh, and finally, is the characteristic of interest and drive. And as I've mentioned before, what makes a good judge to me is someone with the aptitude and the interest in the position. From an interest, experience, and ability standpoint, I feel like I am simply wired to be an appellate judge. Now, I can tell you that over and over again and talk about it all I want, but I believe the best way I can demonstrate that interest is, again, the fact that I've spent vast amounts of my free time over the past 20 years reading, analyzing, summarizing, and speaking about the developing case law in the state. And I can tell you I would not put in that vast amount of time if I didn't have a deep and profound interest in this aspect of the law and in the appellate process. And so I think that interest and drive is important. So I believe I have all these characteristics that I've discussed, and I think they make me the ideal candidate for this position. I will close by saying that if you're looking for someone with some agenda to advance, or someone that's going to wow you with the connections that they have, then I am obviously not your candidate. But if you are looking for someone with the intellect, experience, writing skills, knowledge, and just flat-out internal fire necessary to be a great Court of Appeals judge, then I am absolutely your candidate. Thank you.
Thank you, Judge. We'll start with Mr. Gray.
Judge Ahlers, do you think it's important that the judges on the Iowa Court of Appeals come from different geographic areas, and if so, why?
I do, and I believe that's one of the things that is also a feather in my cap, if you will, is the fact that I think we continue with some geographic diversity. And I'd like to look at it as if Chief Danielson's stepping down from District 2B, I can fill his spot and keep the spread. I think that is important. I believe I was talking with Ms. Bowden in her travels around the state. She's commented on the fact that even though it is just one state, it is not a homogeneous group of folks, and there are different kind of cultures that develop in different parts of the state. So I think it is important to have perspective from rural areas versus urban areas, or east side versus west side, or however you want to break up the demographics on it. But I think that is an important part of it, yes.
Thank you.
Mr. Horbach. Ms. O'Brien.
Judge, do you see any difference in the prosecution decisions being made in rural counties versus urban counties?
All three of my counties that I preside in are rural, and I'm blessed with, in my opinion, are very reasonable prosecutors. I think there are, I don't know that I would even break it down to rural versus urban. I think it can vary from county to county. I handle 3 counties, and they're all different. There are things that happen in Hardin County that wouldn't happen in Wright and Hamilton, and the same could be said of the other 2 counties. They're all different. They all have their own different culture. And I think a prosecutor can have a great deal of impact on what the culture is in the criminal field in each of those counties. So I don't know that it's important, or I don't know that it sways on whether it's urban versus rural, but I think it does vary from place to place just because of the attitude of the prosecutor.
Do you see a role in the Court of Appeals in trying to homogenize or mitigate the effect of different prosecutorial styles and prosecuting rates?
To the extent you can, obviously you have to take the cases as they come to you and the issues that are presented to you to review. But yeah, I do believe that it is important that as an appellate court, that you, the fundamental fact or factor that I think drives the whole process is to make sure that people are given a fair trial. And that's done on procedural rulings, that's done on evidentiary rulings, it's done on everything. So I think it's important to enforce those rules to make sure that everybody gets a fair trial. And I think that would help clamp down on overzealous police officers, on suppression rulings. It can clamp down on overzealous prosecutors in any given aspect or any case. Yeah.
Ms. Roberts?
Yes, good morning.
Good morning.
You have a variety of experience in private practice as well as, serving on the bench. I've heard you say a couple of times the time that you spent working for Travelers Insurance was valuable and will be, an important part of what you bring to the Court of Appeals. Can you explain that further?
Yes. The types of cases that I mentioned, whether it's securities litigation or insurance coverage disputes, class actions, things of that nature, are things I don't think we see on a daily basis in Iowa, and I don't think they would be part of the daily makeup of the cases of the Court of Appeals. But I think those cases do come up from time to time, and I think I'm in the very fortunate position. I think like a lot of practitioners, I was a county seat practitioner that was kind of a general litigation practitioner, so I have the kind of good spread of typical Iowa county seat types of experience. But I think that 3 years of experience in handling those complex claims just gives me an extra layer of expertise that a general practitioner commonly coming from a rural area in Iowa would not have. So I think it's just a nice little nuanced additional flavor to it.
Ms. Conover?
No questions, thank you.
Mr. Bloom?
Well, once again, I have to be careful with my notes in asking this question, but we had a talk about with your stellar academic credentials. I'll give myself credit for this. I think I asked you why you didn't go to work for one of the silk stocking firms in Des Moines, and you responded that you had the opportunity to do that, but you wanted a more well-rounded practice. So we have applicants that fit the first description. Could you sort of make your case why the type of practice you had is helpful for the Court of Appeals?
Yes. First of all, I did make a conscious decision to do that. I had a number of job offers coming out of law school. I had one in Cedar Rapids, one in Des Moines, and one in Kansas City, all with fairly big firms in those three cities. And I turned all those down to take a job up in Spencer, Iowa. And the reason I did that, I think, is because having grown up with a mom who was a legal secretary in the firm I actually ended up going to in Spencer, my idea of what a lawyer was the kind of jack of all trades lawyer in small towns, and I'm proud to be from a small town. And to me, that's always what a lawyer was. And I think doing that, and certainly, and I don't say that with any disparagement of people that have chosen to specialize, because that's an important aspect of our profession as well. But I found it much more personally rewarding to deal with that you could be the lawyer for somebody when they come in for their will, when they have if they get a traffic ticket, to they get a drunk driving charge, to they've got a personal injury case, to whatever. I always found that kind of intriguing, and that's the way I grew up thinking of what a lawyer was. And I think that experience as a lawyer in county seat towns and in smaller areas has given me a very well-rounded experience spread that I think is would be very beneficial that I could bring to the Court of Appeals.
Thank you.
Mr. Goldman?
No
Goodman.
questions.
I'm sorry, I'm gonna get this right. Mr. Mr. Ms. Diekman?
I am the 29th interviewee, so I'll give you a break.
You have to know that when she got her plaque after being president of the Polk County Bar, they put on it Mr. Diekman.
They did. I still have it. Yeah, I kept it. I would like you to walk us through a day in the life of a district associate judge. I mean, different types of things. Just tell us a little bit about what you see.
I usually get up or leave my house between 6:45 and 7:15 because I like to get into the courthouse early and get a good hour or so of work in before what I call the buzzsaw starts. My arraignments start at 8:45, which means people start trickling in at about 8:30, and once that buzzsaw starts, it doesn't stop until you turn it off. It's a very high volume court. So I usually start on a typical day, on a court service day, which is most of my days. I probably have anywhere from 5 to, I think my record's 29 arraignments on one day. I kept track of it, that's why I remember that, because it was like, holy cow. But then a typical day would be handling pleas on indictable cases, sentencing hearings, bail review hearings, suppression hearings, probation revocation hearings. I tend to do that in the morning. One of my counties, I have some magistrate duties, so my afternoons are spent doing initial appearances and then small claims hearings. In my other 2 counties, I do juvenile work, so my afternoons are spent doing juvenile work on those court service days, which can range anywhere from China cases to delinquency cases, can be review hearings, can be initial adjudications, it can be termination of parental rights hearings. Usually termination hearings are long enough that we set those on a special day, so usually if I'm doing a termination hearing, that's the project for that day. And so typically, I grind those out. They're set on about 20-minute increments, which is not enough time to get everything done. So frequently what we're doing is just going through the stuff that we have to do in the courtroom. Then at the end of the day, if the docket runs out at 3 o'clock, then the next several hours are spent cranking out the orders that need to be cranked out for those things that we worked on. And because the buzzsaw will start again the next day, I don't let those orders sit, because it becomes a snowball effect, and they have to get done that day, because I'm not going to have any more time the next day than I had that day. So that frequently results in me staying there till after hours, sometimes typing my own orders if my court reporter's gone for the night, although she's pretty good about sticking around and helping out as needed. So that would be a typical day.
Thank you.
Ms. Sinclair?
No questions.
Mr. Sukup?
Good morning, Judge.
Good morning.
When you reference finishing in the top 3.4% of your law class, I think some of your finance and details is coming out there. So when we visited, you mentioned about, in one of your legal writings, making an unpleasant decision, but it was the right one.
Right. As I've told a number of you, I agonized over that question on the application about your significant legal matters, and the third one I had down, I stewed about it, and finally it kept popping into my head, so I'm going to put it down. I hope nobody thinks I'm being cute. And the reason I listed that case is because that case, even though it happened very early in my judicial career, it has always stuck with me. And what happened was we had a woman who had sued for replevin to try to recover her flea-laden cat from her neighbors. And I remember that because I'm kind of a germphobe, she threw a flea-infested collar up on my bench without me asking for it. So I politely asked her to get that collar off my bench and take it back with her to counsel table. But it was one of those situations where she was just an unpleasant person. She was aggressive and mean-spirited and hostile. She was impolite in the courtroom to me and to the other party. But she was right. She was legally right. And that case always stuck with me because I always knew that as a judge you had the obligation to determine the facts, apply the law, and that generates the outcome of the case. But that one really drove home that fact to me, that it's like, I would love to rule against this woman. But I can't, because she was right. And so it was without hesitation that I ruled in her favor, even though it was an unpleasant task to do that. And that also stuck with me, because I think it would have been very easy to rule just because, oh, I like the other party, she's a pain. There would have been probably no appeal, and even if there was, there's a good chance I'd get affirmed because it was not fighting over any significant matter or money. But it was not a hard decision to make the decision to do the right thing. That's always been instilled in me from a very young age, and so that's why I listed it as a significant matter, because that has always stuck with me as the quintessential example of that.
Thank you.
Mr. Bevel?
Yes, Judge, can you think of one thing that you've done to prepare for an appellate judgeship?
I think the things I've done to most prepare me for that is, actually, I don't think I can think of one. I think it's the whole body of work, from my trial experience as a lawyer to my trial court experience. And as I mentioned before, I think the thing that sets me apart is my doing that case law update for the last 20 years. The level of detail that you need to go into to not only read those or skim them like a lot of lawyers do, to read them thoroughly enough to then be able to summarize them into a meaty paragraph, prepare notes, and go speak about them. It's the deal that if you can teach something, you know it better than just trying to learn it. And so I think those are the things that make me prepared to be an appellate judge.
So have you read Iowa Supreme Court and the Court of Appeals case for the last 20 years?
Other than a 3-year gap when I was at Travelers, when I wasn't doing the case law update, yes.
Ms. Law?
Yeah, I sit on the, I'm co-chair of the ISBA annual meeting committee, and Judge Ahlers' presentations, we specially schedule those because they are in such demand. He does such a good job with those presentations that he's really sought after and enjoyable to listen to. But my question is, do you feel having district associate judge experience versus being a district court judge, does that give you any benefits for applying for the Court of Appeals spots?
I think it does, and I've had the question. I see my red light is on. Can I answer the question?
Yes, go
Okay.
ahead. We don't really enforce it.
Okay, thank you.
The trap door is over here.
Fair enough. That's an important issue to me because I know that that's a hang-up that some people have is, oh, you're only a district associate judge. Aren't you skipping a step by not being a district judge? And I think 2 things on that. Number 1 is I think there's a long history in the state of appointing appellate judges or justices from private practice. And I have no qualms with that. But I don't believe that, given that history, I don't believe that 8 years of trial court experience should in any way hinder me in any way, shape, or form. And specifically to the district associate versus district court judge, I would say this. If you look at in my opinion, the 3 main categories of cases that make up the workload of the Court of Appeals, you've got criminal, juvenile, and domestic or family law matters. Well, if you start with the juvenile and family law matters, district court judges do the family law but don't do the juvenile. District associate does the juvenile, doesn't do the family law. So whichever way you go on that, there's a gap. I have that juvenile experience as a DAJ. I think I filled a gap on the other by my 14 years of experience where half of my caseload was divorce cases. And then if you look at the 3rd category of those criminal cases, the procedures and the evidentiary rules we follow in indictable cases are the same whether it's a district associate level case or a district court level case. So it's the same procedure and evidence. I handled 80 to 85% of the indictable criminal docket in my 3 counties. So when you're looking at experience in criminal matters, I actually handle 4 to 5 times as many criminal cases as a district court judge does.
Thank you.
Thank you. We're out of time, and I really appreciate your application, and we wish you the best of luck.
Thank you.
And I went for the record, established that that red light went off before I got to ask you any questions. You're a very lucky man.
I will consider myself blessed. Thank you.